Fantastic. Thank you, Debbie. We are excited to be here today. I'm going to make this as brief as possible of an introduction. We have quite an audience, at least numbers wise today, and it looks like quite a few fellows on as well, and are excited to have everyone here today. This has been a popular topic, one that has been close to my heart in terms of tracking what's going on, what you see outside the US, and now seeing some private equity investment in the US. I don't know if anybody else is tracking this. A couple of weeks ago in Bloomberg Law, there was some coverage about John Quinn talking about private equity investment being a kind of foregone conclusion in big law for the future, and some even intimations that it was something that he personally might consider. So I think that has the potential to make some changes in our industry, and I'm excited to hear today's conversation. With that, I'm going to hand it over to Barry Solomon. If you do have any questions, please feel free to put them in the chat. I will be helping to monitor that, as will Barry. Barry will be moderating today's discussion. Barry Solomon is with Latera, and he is one of our newest fellow elects who will be inducted in June. So welcome, Barry. I will hand it over to you.
Thank you. As a young lawyer at Sidley Austin, I still remember the sting of being corrected pretty firmly by one of our firm's Office of General Counsel when I just casually referred to the legal industry. He stopped me and he said, "Barry, it's not an industry, it's a profession." And that distinction has stuck with me. And it turns out that that distinction is exactly what kind of sits underneath what this conversation today will be about. For many generations, law firm ownership has been a closed system. Partners own the firm, partners make decisions and govern the firm, and the capital comes from partners from within. But if you look across other professions, healthcare, accounting, consulting, that wall has already come down. Outside capital is already part of how those professions operate, and it's changed them in ways that weren't always anticipated. So the question we're going to explore today isn't a theoretical one. It's a real one. It's whether law is next, and if it is, what that means for our profession. Because underneath what might sound like a business school, business model discussion, the questions are deeper. What is a law firm for? What's our purpose? Who does it ultimately serve, and who gets to decide its future? So we have a terrific group to unpack that from three different perspectives. We have an operator, an investor, and an analyst. But before we turn to the panel, let's just take maybe 30 seconds, because we also have a lot of folks online with us. If we can do a survey, because I think it's going to help us understand who's on the call and online with us today.
Fabulous. And Barry, that poll is live. Just want to make sure you see that. So everybody should have a poll up on their screen. Please feel free to let us know who you are. And while that is kind of filling up, Barry, if you want to continue, you can go ahead, and I can kind of interrupt once we get one introduction in, if that's okay.
Okay, well, this is kind of what I expected, which is about half are from large institutional firms. There are some smaller firms and even in-house counsel. Let's see if there's others. Yes, and then maybe some vendors as well, those that kind of are looking from the outside. So, I think probably the plurality is from traditional, the traditional partnership model, which will make this really relevant. And I think we can just stop sharing and move on then. So let me introduce with just one sentence the three people who are going to help us think through this. And I'm going to give each of them, after I introduce them, the same question. What's the first word or phrase that comes to mind when you hear private equity in law firms? So Mike Schmidberger is chairman of Norm Law, the first AI native law firm, and it's affiliated with Blackstone backed Norm AI. And before that, Mike was chair of the executive committee at Sidley Austin, where he led the firm through a decade of remarkable growth. Mike, when you hear private equity and law firms, what's your gut reaction? Just one word or phrase.
New world.
Yes, New World.
Taking the red pill or the
Seth
blue pill.
Deutsch is the founder and managing partner of Salmon Partners Group, bringing an experienced private equity and serial investor perspective to the conversations. Seth, how about you? What word or phrase comes to mind?
It's a marriage, not a transaction, and pick your partner wisely. And the last
Nice.
part of that is be careful.
Okay, we're going to be unpacking a lot of what you both have said so far. And finally, Jordan Furlong is principal at Law 21. He's one of the sharpest observers of where the legal profession is actually heading, not just what we hope or aspire for it to become. Jordan, what is your word or phrase?
The word or phrase that comes immediately is "Hoi Gewalt." What are we? What are we? It's incredible. Like so much changed from so many different directions, from so much happening, and private equity just brings a new dimension and also a tremendous amount of acceleration and momentum as well. So it's more and more dynamism into a market that previously has been about as close to moribund as you would like to see. So it's yeah, we got it all going on.
It's a huge change. So three different perspectives. Now let's start with, kind of what's actually happening. Mike, I think you're probably closer to this model than most lawyers. So set the scene. What does a private equity-backed law firm actually look like day to day, and how might it be different from what people might imagine?
Well, there's no one size fits all, Barry, and so it depends. I think as Seth was saying, it depends on whom you're partnered with, and what the expectations are of the parties, like any um, transaction or marriage, and how clearly those expectations are laid out. I mean, in the simplest form, um, private equity or outside investors in an MSO model provide resources of one form or another that relieve, if you will, the law firm partner from providing certain functions and supports and allow the partners to not manage themselves as fully. They still will manage themselves a lot, but as fully as they might if they did not have that support arrangement. Um, and it runs the gamut depending on the expectations. Although one has to be quite careful about maintaining independence in terms of the provision of legal advice, making decisions regarding client matters and the rest. And so, with that very broad sort of distinction that really can't be bridged at this time. Um, it just depends on what those resources are, in what areas, what forms, and then the expectations back and forth.
So you're echoing a lot of what Seth said in just a few words, with it being like a marriage. Jordan, from a regulatory standpoint, where do things stand right now?
Well, in terms of the obviously the overall regulatory issue that comes in most immediately on all this is Rule 5.4 ABA Rules of Professional Conduct, and its ilk because there are very similar provisions in many, but not all other countries. Canada, where I'm based, is similar. And that is a rule that says that a law firm may not have any owners of equity or investors of equity who are not lawyers and may not split or share fees with people who are not lawyers. Now, I've been kind of kicking that one around for the last 10 or 15 years. I'm not a big fan, and I've been critical of it in the past for quite some time. I have always kind of felt Rule 5.4 was a pretty good example of maybe overreach or overextension. Kind of use your classic using a hammer as a fly swatter. There is a legitimate ethical goal and regulatory goal behind Rule 5.4, which is to protect lawyers' professional independence. But when I would engage in these conversations for the longest time, and speaking with lawyers and law firms and regulators and so forth, I also get this. There's an undercurrent there of almost scandal. The idea that you could share profits. A person who's not a lawyer, right, is helping to run a law firm, and there's always been this weird kind of assumption that those people aren't they're not as ethical, they're not as trustworthy. If you let them in, it'll be the beginning of the end and so forth. And I sort of felt that was a little bit parochial, and I felt it was a little bit protectionist, which to my mind describes a fair bit of legal regulation. Um, now, I think it's something, and it's not that Rule 5.4 is completely sacrosanct. Of course, Arizona a few years back more or less knocked it out and says, no, we're not doing that anymore, and we may potentially see other jurisdictions do it as well. That's kind of the regulatory angle on the whole issue of private equity ownership and investment in law firms. But to me it kind of goes beyond that a little bit, because what I think Rule 5.4 was always really about, and what I think kind of goes to the heart of where lawyers on this, is the issue of control. Right? Do we have control over our professional practices? Do we have control over our businesses? And the fear of loss of control underlines a lot of lawyer resistance to innovation. There's lots of other reasons as well, which are far more irrelevant. So I think that, and really the whole question of control is what's going to come down. I think that's what's going to determine a lot of the conversation around this, as between if you will, a post private equity law firm, one that, according to the now classic model, would more or less take a lot of its infrastructure and business parts, hive it off into a managed services organization, so that you now have the remnant of a law firm, which is the lawyers practicing law, exercising legal judgment, and so forth, and the business infrastructure over here. The relationship between these two entities is where it's all going to play out. And so I think that's something that we will be talking about a lot in the next several months.
Yeah, I see a theme. The word marriage comes to mind. Seth, from a investor's perspective, what's driving the interest in investing in law firms, do you think?
I think a lot of things, and I think going back to all the comments that were just made, right? Because
Mhm.
you said a private equity backed or private equity owned law firm, I can't remember. And I want to remind everyone that there are two models here, right? One is what you just said, and that is something that can exist, let's say, through an Arizona ABS. But that is not at all the case when you're talking about an MSO. You do not own the law firm, they own the back office and the brand and the NIL, right? So just these are words are important when we talk about this. I just wanted to throw in that distinction to
So
make
how would
sure
an
that
investor look at each of those types of investments, and how, in your experience,
sure.
do the partners look at each of those types of
Yeah, and so I think it varies. And like I know that today, for example, we're talking about, I think most of the people here are from let's just say
traditional large law? Yeah.
traditional corporate law firms. And so how that is looked at is different than how, let's say, a B2B creditors' rights law firm might be looked at, right? That's working on everything's a flat fee, or how a consumer law firm, like a personal injury law firm, might be looked at, right? Very, very different lens. I think that because what do investors, what are they banking on? What is this thing, private equity? By the way, private equity is any outside investor that is not you.
Hmm.
Could be your dad or your cousin, right? It could be, right, and it comes in all shapes, forms, and sizes, right? So that's the way to think about it. And so Barry, it could be you investing in one of your grandkids' lemonade stands, right? And what you are looking for is the predictability of future cash flow. That's what I'm, right? That's what I'm betting on. So that's how investors view things. That's part of what drives valuation and deal structure, specifically in, traditional billable hour legal, especially where you cannot get non-competes on lawyers.
Mhm.
How this is done is different. For example, the deal structures are different than how it's done in a personal injury law firm that is brand driven, technology driven. 96% of the cases are negotiated settlements with insurance companies. There's very little lawyer time and there's no key man dependency versus in a CPA firm or in a McKinsey or at a Sidley where the work a lot of times follows the people and where you can't get non-competes, right? Boy, we got to be careful about, right, how much cash are we paying? And if someone leaves, what then happens? So I think how private equity looks at things, it depends on the sector of within legal. But speaking to traditional corporate law, let me give you an example of a conversation I had with managing partner of a large regional law firm the other day. And the conversation was, our work is starting to go down because in-house corporate counsel is using a lot of AI and shifting work just native in within their own organizations. And we have seen in their one of their practice areas since their clients started to use things like Harvey and Udea, they have seen a decline of 35% of revenue. Question is now, what are they going to do about it?
Mhm.
They are going to have to accept that this is the new reality, which it's dawning on them that this shift has happened. And it's happening much faster than the shift from legal paper to standard paper happened in your profession. I did not say industry, right? This is coming much faster, and we
Yeah.
have to adapt, right? And so the question, so now, so what people are starting to think is, I might have to start thinking about how I'm hiring. I might have to start to think about my utilization, my bench. I might have to start to think about my business model and how I'm selling services. I might have to start to think about technology usage within my firm. And then the question starts to come, am I prepared to do this myself, or might I need help from the outside to make investments and make this transformation in my firm? So, what I would say is that from my perspective, many of these questions are coming from inside of the profession. And
Mhm.
now that technology and alternative models exist, this is now something that um, ownership committees, managing partners, et cetera, can start to contemplate and think about whether or not they engage with private equity is a different thing. Then private equity has to say, when they look at something like a billable hour law firm where you can't get non-competes, and people just can walk out. And so you think about the predictability of future cash flow, which is tied, where work is typically tied to the people, less to the firm in a traditional model, versus something that, let's say, Mike and his team are creating from scratch, a very different way of practicing with the help of outside capital. I think that outside capital is taking a look at this and saying, okay, well, look, we are a litigious society, right? This profession is not going anywhere. It's a very large, fragmented market. It's a professional services. It's a profession that's never been, it's been consolidating itself for a long time, just as the CPA space had, right?
Yeah.
PricewaterhouseCoopers, Ernst& Young, Deloitte, and right? The Big Four have been consolidating themselves the way that law firms have for a long time. Wow, there's a really, really big market here that also might need our help. But when we look at a deal structure and investability into something that has a lot of key person dependency versus looking at other sectors of legal, and when we also take a look at the public comps in the UK and Australia, right, where has value been created, et cetera, it's a complicated lens. I've already taken up too much time, but
Mhm.
but 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 it's just to say that right? Private, like, of course, outside investors are going to be interested in a $400 billion professional services market that's never been consolidated.
So
And
Jordan,
so, anyway, lots there.
Seth has made the case for why investors should be interested and why law firms should consider accepting private equity. But let's talk for a moment about the clients.
Mhm.
Is there a version of this where they genuinely benefit? Maybe it's, you know, more resources, or as Seth said, and as Mike's living, more technology, lower costs.
I'm
Or,
gonna, before we hand it over, I'm just going to say a truth, which is one of my clients needed to do an employment contract a few weeks ago. They went to their large law firm and it got passed around to 11 people and it came back with a $30,000 bill, which they refused to pay. And then they themselves used Claude and hired a local employment attorney. And by the way, that process took 3 weeks. They scrapped it, said thank you, no thank you. Then they went to Claude and a local labor and employment attorney. And within 2 days, for $2,500, they felt they had a much better product. That seems pretty good to me for the client. Anyway,
so, Jordan, you agree, disagree, see it slightly different or the same?
I think the angle with clients is a really important one, and I think that Seth's observation about the degree to which, especially corporate clients, are very intentionally adopting the use of AI, primarily AI. I mean, other than of other technologies as well, but they understand what it can do, and they're starting to adopt it and adapt to it, and we're starting to see the impact on the type of work and the amount of work that's coming to law firms. And I've had conversations in the last 2 weeks, one with the GC in the US, one with a senior in-house counsel in Britain, and they see this coming, and they are very intentional about it. I had one of them actually said to me at one point in the conversation, "I don't know what's going to be left for law firms to do." Right. So I think it's important to appreciate that, especially because of AI, we are experiencing, I think, an unprecedented degree of client empowerment. The ability to access legal answers, access legal information in ways haven't before. I was at an event in Denver a few days ago, and the way that I put it was because that was kind of for smaller firm lawyers, and I said when it comes to products or services like legal information, legal research, even legal direction, if you don't want to call it advice, the going rate for that right now is $20 a month. Because that's what it'll cost you to get the best version of GPT 5.5 or the best version of whatever else is coming out there. And that was a sobering moment for a lot of the folks there. So,
yeah.
so the first thing to know about clients is that they are settling into the driver's seat and they like it, and they're going to stay there for quite some time. Clients make a lot of assumptions and presumptions in dealing with professionals. Barry, I think your point about the profession versus industry is actually not just a semantic one in a lot of respects. This is, it's $400 billion in the US every year, $800 billion worldwide. It's hard to call that a profession. I think you can call it market, you can call it industry, but it is still a professional industry. It's a professional business. As I'm fond of saying to when I give speeches to law firms and so forth, that a law firm is not a pizza parlor and it's not a hair salon. And there's nothing against pizza parlors or hair salons. They're great, but there are different obligations and different requirements and different aspirations in a law firm. When you are a client of a law firm, among the things that you assume when or presume, I guess, depending how you want to look at it, when you retain a lawyer or a law firm to help out with something, is that they come with a whole package of ethical guidelines and ethical underscores. And the number one behind all that is the lawyer is going to act in my best interests. Right? They're going to give me some direction. They're going to give me some advice. And whatever they give to me is going to be.
How are you?
Hi, folks. Someone's got their microphone on. If you could mute it, that'd be awesome. Thank you so much. And I think that is something which we're kind of accustomed to in the law that we don't really necessarily think about, and clients don't think about it either, right? It's kind of built into the infrastructure of working with a lawyer. When you come when you're looking at issues around clients, what are clients interested in? They're interested in effective service, affordable service, and they are interested in getting the answer that they need in a timely and an accessible manner. But there are also, again, presumptions that come with that around how the lawyer will conduct themselves. So when you're looking at the idea of new forms of equity, new forms of financing from wherever they might come, coming into a law firm, I think the client generally says, I don't care that much, honestly. I don't think they've given any thought to with the way the partners, split the money amongst themselves. They don't care, but they have baseline assumptions, and it's those assumptions or presumptions we have to make sure not just survive this transition, because there is going to be, whether it's from private equity or wherever else, new capital is coming into the legal market. The ethical and professional responsibility considerations have to remain at the core of what we do, and that's not just a oh well, it's lovely and nice and we should have got to do this. As any investor will tell you, I'm not going to invest in a firm that has blows off its ethical considerations, because then my investment goes down the tubes. So part of the way in which we can address all this, and to ensure these kinds of issues come up, is again understanding the relationship between the law firm and, again, working with the MSO entity, because here in North America, that is 95% of the situations you're going to have. How does that relationship function? And I think that the number one point we need to take going forward in all this is, if we are going to have new equity coming into this profession, there's got to be a very strict, clear, transparent governance structure around that. I don't want to go into huge detail about this. I'm dropping into the chat right now an article that's coming out in a forthcoming edition of the Yale Law Journal, written by a law professor at William & Mary named Lev Brado. Very interesting stuff, very even-handed, I think. And he has, among other things, a series of recommendations about this is the kind of structure that you need in terms of governance. You need independent boards of directors. You need ethics committees with veto authority. You need a compliance officer at the MSO. And the reason, and I'll just come in for landing on this. And it's my view, this is all of this governance architecture and infrastructure is not solely, or maybe even primarily, to restrain the MSO, to keep it from getting, because that's the fear, right? The fear is that, to say, they are so focused on profits, they're so focused on throughput, that they will put undue pressure on the law firm. And that is a legitimate concern. And it's come up in other industries as well. But it is at least as important for the lawyers and the law firms, because among the things law firms don't do very well is governance, right? Law firms are not particularly well run or very formally run businesses. Governance tends to be personal, tends to be interpersonal, tends to be passive aggressive, all sorts. Everybody here who's been in a law firm knows how stuff actually gets done, and it's not always the most sensible way of doing it. So a governance structure around this will be useful, not just for maintaining that element of professionalism and ethical infrastructure, which is going to be so important, but also to give the lawyers a sense, look, this is the NFL, right? You're moving into a whole new industry, a whole new area here, and you've got to have very clear sense for yourself of what you can and what you can't do, what you should and what you shouldn't do. Those are conversations we have not had enough of, remotely enough of, in the legal profession. We're going to have them all, I think, right now.
So, Mike, I was going to move on to another question, but I want to give you an opportunity to respond to both Jordan and Seth, especially in light of some of the conversation around the investment that law firms can get in AI, which can be very expensive for some firms. Do you have any thoughts on what you've heard so far, or should we just keep going?
Well, it isn't just AI that's expensive. If you look at cyber and other, costs are going up dramatically, and the need for those kind of infrastructure, guardrails, are the same at medium size and large firms, and so there is an economic imperative that is out there too. The one thing I would say is I, of course, agree with Jordan about the ethical considerations and the rest. But in terms of looking at stepping back, it's not the greatest thing in the world that the largest provider of medical advice is ChatGPT. And it is not the greatest thing in the world that the largest provider of investment advice is ChatGPT. And while democratization of legal knowledge is a good and empowering thing, it will not be the greatest thing in the world if the largest provider of legal advice is ChatGPT. Um,
Hmm.
and so, I do think there is a place for the profession to be democratized in a way that is beneficial for society, and yet, as Jordan says, adheres to the standards and requirements and imperatives that are the guardrails around a profession. So again, it's all in the implementation, but I do think there is a way of thinking about this that ultimately is more beneficial to society than just allowing the guardrails to come down completely and deferring to completely unregulated providers, whether it's healthcare, law, or investment advice.
Yeah, so all of you are getting at, I mean, Jordan described just a moment ago, clients want high quality legal services, clients want reasonable cost, but they also want no surprises. They want to mitigate their risk. And so, let's talk specifically about risk next. I mean, Mike, clients, I always hear hire lawyers, right? They're not hiring a capital structure. So how do you, well, they hire firms, but
Yeah,
how in
it depends. It
practice,
depends. Yeah, it depends on
yeah,
what
yeah,
they're
it
looking
depends upon the
for.
issue and the client,
Yeah,
but
what they're looking
how,
for.
how do you assure a client that the judgment they're paying for hasn't been, subordinated to someone else's financial interest?
Well, I think Jordan would tell you that the model rules, prohibit that regardless, that we're all bound by conflicts requirements and to put the best interests of the client first and not have that interest subordinated to another client. It's the same concept and really no different at all in terms of whether or not you have a provider of services to the firm. Uh, you can't subordinate your judgment and best efforts to another client or to a provider or to your spouse or your cousin. I mean, it just I think you have the same guardrails are there regardless. And there's really that is one of the important things is there are places where there are distinctions and then there are places where there are not. And um, I think making sure that we keep clear about things that are not susceptible to compromise is important as you go through these conversations.
Okay. Well then, Seth, from where you sit, what are the risks that you see? What keeps you up at night about this, asset class and this type of investment?
Well, I'm too old to be kept up at night by work. So let's
Good.
just say that. But I want to answer your question. I want to lead in with something because I
Okay.
think this is important for people to understand. And then I'll tell you the thing that keeps me up, if there were something. Let's talk about all the regulated industries in this country that have not only um, private equity, but also public company investment,
Mhm.
um, accounting, healthcare providers, health systems, physician practices, dental practices, veterinary practices, behavioral health and addiction clinics, pharmacies, compounding pharmacies, life sciences, medical devices, clinical labs, health insurance and managed care, banking, registered investment advisors, insurance carriers, asset managers, mortgage lenders, utilities. I could go on.
Mhm.
Right. So this is not new. And I think one of the things that this industry lacks just because of its structure, because my wife was an audit partner at PricewaterhouseCoopers. Of course, they haven't taken on private equity, but the industry has. And I haven't looked into this, but of course the AICPA, which is part of the PCAOB, which is part of the SEC, governs the ethical line kind of in the structure, right? That's set up for CPA firms. And what's really interesting, and I'm shocked by this, that the industry was not railing to say, how are these investors, right, going to protect us to make sure that auditors are not filing audit opinions, right, that are in the interest of their investors? Where's the uproar? Lots more uproar here. I've got different opinions about that. I'm not from your industry. I'm a business person who helps founders do things they want to do. But anyway, I just think we have to we need context, right? And I think the thing is, from my perspective, there are lots of founders and entrepreneurial managing partners and firms that have a vision of what they might want to do that outstrips their ability to do that themselves with their own capital. And like it or not, I think that in this country that they should be able to with the right ethical structures, right? And it's just what I believe because we stand for founders. The thing that I worry about is that the wrong marriages will happen. The thing that I worry about is that, especially in the corporate sector, that we are not studying the lessons from other industries, but this industry specifically, when you get into like big law, the compensation adjustments, the benefit adjustments, right? Uh, yeah, all of these things that have to be done because what are investors investing in? They're investing in predictability of cash flow and retain net earnings, right? And so I think we have to really study what's worked and what hasn't worked in other professional services. Because like I started my career in engineering, right? I built one of the largest private equity backed and then publicly traded engineering firms in the world. So we've dealt with it there. We've dealt with it in CPA. I did my own roll up in accounting. Compensation structures here on this audience's side of the equation, very, very different. And so what worries me is that in any sector of legal, someone's going to pay too much. Someone's going to overpay, put too much debt on one of these things, not understand human behavior on the other side as we deal with things like compensation and benefits, and screw it up. That's the like I have yet to speak to an investor that wants to go tell a lawyer how to practice law. Have yet to do that. And by the way, when I joined an engineering firm, which was 8 billion in revenue at the time, when I left, we were 20 billion. The business that I grew there was this. I was a chief commercial officer, but this fledgling little business there that me and my team took from 25 million to 2 billion in revenue. I had 10,000 employees in 80 countries. But it was this combination of what I knew how to do as a business person, the other business people that I brought around it, and the heads and the professional technical service folks within that firm that wanted to do great things. And this combination of talent that we were able to bring together along with capital being publicly traded enabled us in 6 years, right, to create a $2 billion enterprise. And I think that other professions deserve the same opportunity. But what keeps me up are the wrong marriages, and on both sides, people chasing a transaction and not thinking about the unintended consequences of doing things that are too much change too fast, not understanding human behavior, right? And also if when we see things that get bid up too high, typically what happens is more leverage is going to be used. And then, and so we are a big proponent in these deals, especially on your side of the equation, all equity, no debt at the beginning. Be conservative with leverage, please.
Yeah, Barry, I agree fully. But what I would also say too is that law firms have been failing without the added assistance of private equity since I've been practicing, and they fail for all the reasons Seth said. Strategy is not aligned with capability. Strategy is not aligned with resources. Um, the decisions to engage with the wrong kinds of clients, decisions to engage in the wrong kind of matters, um, regulatory change outstripping their ability to keep pace, all of these. And there is the potential for more professional assistance to be more stabilizing. It can go either way, though. Seth is exactly right. There will be mistakes made, but managing partners, particularly in the time that we're entering now, where there is going to be a lot of change driven by AI, are going to have to really think hard about their defensible competitive advantages and the threats, to their business and where they need to pivot, to be successful over the coming period of change. And a thought partner may be in outside investment or it may not. But they're going to need to navigate some pretty rough waters, I think.
Mm. Jordan, you had said earlier that you don't think law firms do governance particularly well. Do you think this makes that harder or easier? Would a good marriage is that helping the situation between investor returns and professional independence, for example?
Well, I've written a fair bit about law firm culture over the years, and not usually in a very complimentary fashion. Um, and it's difficult to define, and I think it's also the way lawyers tend to look at it tends to be a little bit self-gratifying. But I do think there is such a thing as the culture of a law firm. I think that what if I'm running a law firm right now, or in any and when I talk about law firm, I'm talking like mid-sized, larger firms. There are separate conversations to be had about smaller firms and niche practices, which we're not, I don't think, going to have time to look into today. The point I think I would like to make to law firms in that situation is, even apart from private equity, um, we are we're right now experiencing a period of profound change. Law firms are not going to look the way they do today in 5 years' time, certainly not in 10. They're going to be smaller in terms of the number of lawyers that they have, I believe. They're going to be far more automated, far more mechanized and technology based. And that's at the minimum. I think there's a lot of scenarios where it could be far more significant. Private equity brings in, and the MSO model in particular brings in an entirely new concept. And it's one that I think, again, if you're a law firm, you need to think in practical terms around what it means. So, again, the idea is we will take the infrastructure, we will take the parts of your practice parts of your firm that don't practice law, we'll kind of hive them off into this MSO, and it will be able to do this a much more efficient. The MSO will run the operations of the firm and the infrastructure and the administration of the firm more effectively, more profitably, and more probably usefully in many respects than the law firm did, which I think is probably true because, again, I don't think law firms are great management or administrative places. I don't know that the partners necessarily appreciate, however, just how much of the firm that is. Because you say, okay, well, what we leave with the lawyers is all the stuff that is about the practice of law and the use of legal judgment. That's a remarkably small amount of what goes on in law firms. It's a remarkably small number of people involved with it. And when you essentially externalize all the kind of operations of the firm to the MSO is unlikely to stay a static operation over the course of the 10, 20, 30 years, however long the agreement is. It varies from place to place. There's a pretty good chance that it's going, in fact, more than a chance, this entity is going to want to get more infrastructure from other law firms. The idea is kind of you want to scale it up. That's where a lot of, not all, where a lot of the efficiency economies of scale come from. So pretty soon, this entity to which you have outsourced and externalized a lot of the operating and structure of the firm is going to be huge. It's going to be bigger than you are, right? And it's going to have a real momentum associated behind it in terms of because they have directives in terms of their growth, in terms of their profitability, in terms of where it winds up going. So, and there's elements of that that I think law firms need to think about. What happens, for instance, with the development of new lawyers and associates? Again, AI is going to take the legs out from under that anyway, because all the work that law firms traditionally gave to their new lawyers to say, here, immerse yourself experientially and all this stuff, do it again and again for years. You'll get the hang of it. You'll deepen your knowledge. You'll develop legal judgment. We don't know how. It's alchemy. It's wonderful. We love it. But you'll develop all this ability to be really good lawyers. And in the meantime, we will bill all that work out to the clients and make a bundle of money off it. We'll pay for your salaries and we'll get some profit to it as well. And that's done, essentially, right? I spoke to a large law firm here in Canada a few months back and I said, I got bad news for you. Your associates are moving from the revenue column to the cost column. They're going to be
Yep.
investments from now on. So where does in this new operation, if the law firm is here, or again, what's left of it, the lawyers, exercising legal judgments here, and the MSOs over here, where does new lawyer development reside, right? Because it's going to be an investment. And it's going to be a not particularly great investment, right? It may be something where because we all know already, you hire 10 associates on day one, and in 10 years' time, maybe you got one partner, right? The rest have kind of left through attrition. It's not a really great use of talent, but the broader point though is that that is something that law firms have traditionally done, and there's good reasons for them to do it, both for the firm itself and also for overall professional continuity. We've got a crisis coming up in that regard anyway, so
Yeah.
we need to think about where does this reside? Where does the capacity of generative AI reside? Right? The idea is
Yeah.
that we're gonna export the technology to the MSO. Okay, if that's basically just Outlook and IT, that's awesome. If it's the generative AI system, we know that generative AI is practicing law right now because it's replacing the functions of lawyers who've been doing that for many years. So where does that reside? These are all the issues that I think we've only begun to think about. And I'm not saying they're irresolvable. They can be resolved, or at least they can be addressed and dealt with. But I think both Seth and Mike have emphasized the importance of caution, the importance of deliberation in this sense, because this whole idea of again with the MSO model in particular, but with any kind of new equity ownership structures coming in, we're in a whole new world for lawyers, and we don't tend to react real well on short notice to
Yeah.
change. But we're going to have to get our heads around it again
Yeah,
real
no,
fast.
no, no
We're,
human does,
we're,
Yeah,
right?
yeah, yeah.
But we like to, I used to say when I was running professional services firms, no one likes change unless they're driving it,
Mhm.
yeah,
right? And
we are living through this right now. And
right now, listen, here's the thing. Forget private equity. Jordan just said it, and I want to hear much more from Mike. Jordan just said it. I just want to chime two things, right? Forget private equity, forget MSOs. This change is happening to your industry
yeah,
right now faster than you imagined. And so you have to deal with this anyway. Number two, and gosh, I'm so old now, but I think part of Jordan, Jordan was talking about just from a professional development perspective, COVID really already impacted this because look, there's the words on a page, and then there's how you manage a client, how you deliver news, how you sway and influence, these types of things. You have to be in the room, right? So
yeah,
we've already lost a lot of reps on this.
yeah.
But this is something that every professional service, not just legal, every professional service is going to be dealing with this anywhere where like the only protected industry right now are the other side of my business. I own parts of 11 blue collar businesses. I am not concerned right now
Yeah, it's
about my
different.
technicians being replaced by robots at this
Yeah.
moment. But in all professional technical services where humans are not required to move atoms, transformation is upon us. Whether you need outside capital or whatever, you have to address it.
So, Mike, Jordan just talked about lawyer development, and I agree with Seth that problems are happening with or without private equity or MSOs. But in your judgment, does private equity and MSOs help or hurt this, or is it just a completely different a problem that's not really related? Oh, you're on mute. I don't know how that happened.
They could be connected, but it would be more happenstance. I think the problem is upon us of training younger people, but I think the answer um, is to train young lawyers, like the McLaren F1 team trains drivers before they let them in a $150 million car,
Mm,
and that is through simulations and that. And I think you're going to see this AI is going to impact universities too, in the terms of
mhm.
people will learn much faster because they can run through experiments just like they can run through cases or deals on a simulated basis, because the AI doesn't just give you the output, it gives you all of the reasoning that happened along the way. And so you fundamentally learning is going to accelerate in the firms and in the places where people attend to it. The other thing that may happen, which could be very good for the profession, is instead of hiring for such planned obsolescence, you can hire for the people that you need and then you can train them. And if the AI can be working at 2 in the morning, you may find that you don't have the same level of attrition that you have today. So I do think there are some positives that could come out of a differentiated training model. Do you still need
Mhm.
humans working with, yes, to get the best results, whether you're talking about medicine, investment advice, or law? I think ultimately having humans in the loop
Yeah.
is important, but I think a lot more can be done with training to frankly make it better.
Before I'm cognizant of time, and Jordan, I'm going to turn to you to see what we can learn from other markets. I mean, the UK and Australia, I think, are a little bit ahead of the US and maybe Canada on this. What have we learned, or what might we learn from what's happening there?
Yeah, early returns, because again, this is all relatively recent in legal profession terms. In the UK, there's been a ton, relatively speaking, of private equity, and that's not they don't have the MSO model. They have the full. We just buy the whole firm. The majority, significant majority of those matters have been for personal injury law firms, and certainly the attention that I've seen or detected in the US has been along those lines as well, which makes sense because going back to the points both Seth and Mike have made, these are practices that don't tend to be specifically lawyer driven, right? I mean, I come to the U.S. on business, and it's like personal injury law is keeping the billboard industry afloat in your country, because they're all over the place, and they're fundamentally franchises, and I think that so private equity probably is a good fit in that regard. You see some of it in family law, some of it in the states, so forth. That's kind of early on. We'll see how that one goes. There's pros and cons. Australia, similar thing. Australia has some really interesting lessons for us in terms of because they've had non-lawyer capital in law firms for coming up in 25 years now, to a greater or lesser extent. And the one takeaway that I want to specifically say for Australia, there was of course talking through this, and the name of the firm on the tip of my tongue, it's going to go away, but it was the first law firm that really they floated shares on the market. They went on huge acquisition sprees and so forth. They opened up a whole thing in England and so forth. People probably know which firm I'm talking about. The name will come to me after I log off, and it's like, oh my god. But um, what was interesting about this, I looked at the prospectus of this firm when it first went public, and they listed the risks. And one of the risks that was listed was keep in mind, future potential shareholders, you have a tertiary interest in this firm. The law firm has two interests ahead of you, and this Slater and Gordon. Thank you, Lisa. Um, and the secondary interest is we owe duties to our clients. The primary interest is we owe duties to the court. So you're always going to be third in the list. And that's from a pure shareholder
Mhm.
point of view. If you start looking more at stakeholder analysis of duties and so forth, then who are the other stakeholders of the firm and so forth. So there are lessons that we can absolutely learn from these other jurisdictions and figuring out, what have they done and so forth. We haven't seen particularly, and again, Slater and Gordon was largely a personal injury firm as well. We haven't
Mhm.
really seen so far um, private equity or non-lawyer equity and a large full service law firm. That's not to say it can't work. That's not to say that there couldn't be a fit worked out. I think again, there's issues all sorts of different ways, but we have a limited experimental range so far to look at.
Jordan, thank you. We're going to stay with you and do a lightning round, less than 1 minute for each of
Great.
you,
All right.
which is just if there is a managing partner listening to this, either live or in recording, and they're considering private equity investment in their firm, what one thing would you suggest they think about before they make that decision, Jordan?
The question I'd be asking myself, and I would expect the rest of my board to be asking me, is why are we doing this?
Mm-hmm.
Why do we want to go down this road? What are we looking for? Right? What goal do we hope will be achieved? What will this law firm look like 3 years, 5 years down the road that's going to be different from what we could have done? Are we trying to solve a problem? If so, what precisely is it? Are we trying to grasp an opportunity? If so, what precisely is it? And then are there other ways in which we can solve these problems or grasp these opportunities that don't necessarily require us to hive off a good chunk of our firm into a separate entity? And the answer may be no. The answer may be this is the best way, maybe even the only way for us to effectively do this for a lot of reasons.
I'm going to interrupt and let Seth answer the same question.
Okay, fire away.
Advice to a managing partner in a minute.
Taking the baton.
Yes.
Why am I doing this? And it's got to be because I've exhausted all of my internal options, and what I want to do and what I want to achieve requires help. Number two, there are 6,000 private equity firms in the United States. 6,000. Pick your partner wisely. This is a marriage. And so as you're thinking about this, you want to understand, have they done this effectively in other industries? Have they worked with other professional technical services? What is their track record of performance there? And are they a good cultural fit for you? What do they bring to the table beyond capital? Because everyone has money. It is, what are you looking for in this partner to do the thing that you cannot achieve yourself?
Okay. Mike, thoughts?
If I were talking to a managing partner of a medium to large law firm, I would quote Yogi Berra, who said, if you don't know where you're going, you'll wind up somewhere else. And I think, just to echo Seth and Jordan, you really have to understand what's happening in a period of change, private equity or not. Um, and it's coming your way, and you do the best you can to work through all the different considerations and imperatives and be honest with yourself about the capabilities that you currently have.
Well, we started with the idea that that law is a profession, not an industry. And what we're hearing clearly right here is everything depends upon who you partner with as we go down this path. So thank you to the panelists, and thank you for all of you who joined us. This was a fun discussion.
Wonderful. And I think Debbie is still on, but we are going to have a couple of evaluation questions we've just launched. If you have another moment to stay on and just answer that, we would appreciate it. And thank you to all of the panelists. I will say we had great retention numbers all throughout the entire program today.
Cool. All right. Thank you all.
All right.
Thank
Bye,
you.
all.
Be well.
Thanks.